Before most Americans poured their first cup of coffee this morning, something absolutely extraordinary happened at the Supreme Court. Something so unprecedented that constitutional experts aren't just calling it a victory, they're calling it a seismic shift in American law. While the 24-hour news cycle was screaming about the latest political drama, 9 justices, conservatives and liberals, men and women from completely different worlds with ideologies that usually clash like lightning and flint, did something they almost never do anymore. They agreed, unanimously, 9-0. And what they just struck down will send shockwaves through state legislatures across America. This isn't about some obscure tax loophole or a dry procedural rule. This is about a law that's been hiding in plain sight for nearly a decade, affecting millions of Americans, and until 48 hours ago, almost nobody was talking about it. The implications of this decision will ripple through every single state in the union. But what's even more stunning than the decision itself is how this case ever reached the highest court in the land. If you haven't subscribed yet, do it now, because what I'm about to reveal will change how you understand your constitutional rights forever. This story has everything: government overreach, a hidden law, and a Supreme Court decision that literally nobody saw coming. Let me take you back 18 months ago to a small town most people have never heard of. What happened there set off a chain of events that would eventually unite the most divided Supreme Court in modern history. Here's what they didn't tell you on the evening news. A state law, buried deep in administrative code, had been quietly expanding government power in a way that should terrify every American, regardless of whether you lean left, right, or center. This wasn't some technical regulation. This was fundamental. This was about your privacy, your property, and your constitutional rights. The law in question gave state officials unprecedented authority to conduct searches and access private information without traditional warrant requirements. Now, I know what you're thinking. We've heard about Fourth Amendment issues before, but this was different. This law created a loophole so wide you could drive a constitutional truck through it. It allowed authorities to bypass protections under circumstances that were disturbingly vague and broadly defined. For nearly 7 years, this statute operated under the radar. It wasn't making headlines. It wasn't trending on social media. Legal activists weren't protesting in the streets. Why? Because it was strategically crafted to avoid attention. The language was technical, buried in subsections, and implemented so gradually that most citizens never realized the floor was being pulled out from under them. But someone noticed. A civil liberties attorney stumbled across this law while researching an unrelated case. What she discovered kept her up at night. The statute essentially allowed law enforcement and state agencies to designate certain situations as administrative emergencies, a term so vague it could mean almost anything. Under this designation, officers could enter private property, conduct searches, access communications records, and seize materials without ever speaking to a judge. The state's defense: they argued it was necessary for public safety and efficient government operations. They claimed traditional warrants created dangerous delays. They pointed to cases where immediate action supposedly protected the public. But the attorney saw something else, a blueprint for unchecked power. She began documenting cases, and the deeper she dug, the darker the story got. A homeowner whose property was searched because a neighbor reported suspicious activity. No crime, just suspicion. A journalist whose phone records were accessed because regulators claimed to be investigating a complaint. A small business owner whose private records were seized during what officials called a compliance verification. In every single case, no warrant, no judicial oversight, just government officials deciding on their own authority that they had the right to enter, to search, to access. Initially, when these cases were brought to civil liberties organizations, there was skepticism. People thought these were isolated incidents. Unfortunate, but not systematic, they said. But as more attorneys started looking, they found a disturbing pattern. Dozens of cases turned into hundreds. All across the state, this law was being used far more aggressively than anyone realized. The legal community realized they needed to challenge the law directly, but they knew they couldn't just walk into court with a pile of papers. They needed the perfect test case. They needed someone whose situation was so clear, so sympathetic, and so constitutionally problematic that no court in the land could ignore it. They found that case in Jennifer Martinez. Jennifer Martinez is not a professional activist. She's not a wealthy litigant with unlimited resources. She's a 38-year-old high school civics teacher. She teaches American government. She coaches the debate team. She's exactly the kind of person who believes in the system. And she literally teaches the Fourth Amendment to high school students every single year. But what happened to Jennifer reveals exactly how far government overreach had gone under this hidden law. On a Thursday afternoon, Jennifer received a letter from state authorities. The letter informed her that her personal communications records had been accessed as part of an investigation. Jennifer was confused. She hadn't been accused of anything. She hadn't been contacted about any investigation. She certainly hadn't consented to anyone accessing her private communications. She called the number on the letter and spoke with an administrator who explained that Jennifer had sold some used textbooks online and someone had filed a complaint. As part of their investigation, the department had used their statutory authority to obtain her complete messaging history, her email correspondence, and her location data. Jennifer was stunned. The textbooks were absolutely legitimate. She'd used them in her own college courses, but more importantly, as someone who teaches constitutional law to teenagers, she couldn't believe the government had accessed her private communications without a warrant, without even notifying her first. That's when things took a dark turn. When Jennifer pushed back and asked about their legal authority, the administrator's tone changed. They informed her that refusing to cooperate could itself be considered obstruction. They suggested that if she had nothing to hide, she shouldn't be concerned. Jennifer knew this was wrong. She knew it violated everything she taught her students about the Fourth Amendment. She decided to fight. Now, before we get to what happened next, you need to understand why a 9-0 Supreme Court decision is so historically significant. When was the last time you saw a unanimous Supreme Court decision make national headlines? It's rare, extremely rare. In recent years, the Supreme Court has become infamous for 5-4 splits along ideological lines. That's become the norm. So when all 9 justices agree, when there's not a single dissent, you need to pay very close attention because it means something profound just happened. A unanimous decision sends a message that transcends politics. It says this isn't about conservative versus liberal judicial philosophy. This is about bedrock constitutional principles that every justice, regardless of their ideology, recognizes as absolutely non-negotiable. It's the Supreme Court speaking with one unified voice to say, this crossed a line that cannot be crossed. But here's what makes this particular decision even more remarkable. This wasn't a case where the constitutional violation was obvious to everyone from the beginning. This was a carefully crafted law with sophisticated legal language, legislative findings, and policy justifications. It had been reviewed by state attorneys. It had been defended vigorously in lower courts. Yet when it reached the Supreme Court, all 9 justices saw through the careful wording. They recognized it for what it truly was, an end run around the Fourth Amendment's protection against unreasonable searches. The legal journey was long and frustrating. The state argued that Jennifer didn't even have standing to challenge the law because she hadn't been charged with any crime. The district court initially agreed, dismissing her case on procedural grounds. Jennifer appealed. The circuit court reversed in part, acknowledging she had standing, but then upheld the law as a reasonable regulatory measure. That's when her attorney made the critical decision to petition the Supreme Court. Normally, the court only hears a tiny fraction of cases. They receive thousands of petitions every year and grant review to maybe 70 or 80. The odds were dramatically against Jennifer, but something about this case caught the justices' attention. The Supreme Court granted certiorari. They agreed to hear the case. When the oral arguments happened, the atmosphere was electric. Usually, you can predict the questions based on who appointed the justice, but not this time. Justices from both sides of the ideological spectrum were hammering the state's attorney with tough questions. The state's defense was sophisticated. Their argument went like this. We're not living in 1791 anymore. We live in a world of complex digital fraud, online scams, and cybercrime that the founders couldn't have imagined. Requiring a warrant for every investigation would paralyze the government's ability to protect citizens. By the time they got a warrant, evidence could be deleted, bad actors could disappear. They pointed to precedent. Cases that had recognized some regulatory exceptions to warrant requirements. They claimed their law included safeguards, requirements for documented justification and supervisory approval. They brought in experts who testified about situations where immediate access prevented ongoing fraud schemes. It was a compelling argument. It's why some lower court judges bought it, but the Supreme Court saw through it completely. Conservative justices expressing deep concern about government surveillance, liberal justices worried about discriminatory enforcement and the chilling effect on free speech. The questions became so pointed that some commentators predicted a broad decision. But nobody, and I mean nobody, expected what actually happened. When the decision was released, it wasn't just a win. It was a total, unanimous rejection of the modern regulatory state's attempt to bypass the Bill of Rights. The opinion, penned by Chief Justice Roberts, didn't just side with Jennifer Martinez. It surgically dismantled the very idea that government convenience justifies constitutional shortcuts. There is one line in that opinion that legal scholars are already calling the most important Fourth Amendment sentence of the 21st century. Roberts wrote, "The inconvenience of constitutional compliance is not a justification for constitutional violation." Let that sink in. The Supreme Court effectively told every government agency in the country, we don't care if getting a warrant is slow. We don't care if it's inefficient. The Bill of Rights wasn't written to make the government's job easy. It was written to make the citizen's life free. Justice Gorsuch, in a blistering concurrence joined by Justice Sotomayor, a rare left-right alliance, noted that regulatory searches can be even more invasive than criminal ones. If the police suspect you of a crime, you have the right to an attorney and clear protections. But if a regulatory inspector walks in, they can often shut down your livelihood without you ever seeing the inside of a courtroom. The court went even further. They established that Fourth Amendment warrant requirements apply with full force to digital communications and data, not just physical searches. Several lower courts had been creating exceptions based on the theory that digital data somehow deserves less protection. The court rejected this emphatically. Your phone contains more intimate information about your life than your home ever could. The idea that accessing this deserves less constitutional protection is, in Gorsuch's words, a dangerous fiction born of technological ignorance. Now, I promised to tell you about the other states, because this decision didn't just change the law in one place. It set a binding precedent for the entire nation. Legal experts have already identified 11 other states that have warrantless administrative search statutes currently on the books. These laws cover everything from business inspections to public health checks to digital data access. As of this morning, those laws are constitutionally suspect. We are already seeing civil liberties groups filing lawsuits, using this decision as a legal sledgehammer to strike down similar statutes. If you live in one of these states, a hidden law might be sitting in your state's legislative code right now. But thanks to Jennifer Martinez, they can't use it. So how does this actually affect you, your family, and your business? This isn't just high-level legal theory. This is a toolkit for your protection. First, if a government official shows up without a warrant, whether they're from the health department, building inspections, or a regulatory board, you have the right to say no. You can politely inform them that you are requiring a warrant for entry. Second, the government can no longer just scream administrative emergency to get around the rules. They now have to prove to a judge that there is an immediate objective danger. Vague concerns about compliance no longer count. Third, if you run a business that holds customer data, this decision provides significant protection against aggressive regulatory demands. Government agencies often pressure businesses to turn over information with implicit threats. This decision clarifies that constitutional rights don't evaporate because the government has regulatory authority. Fourth, this decision potentially creates grounds for challenging previous enforcement actions that resulted from warrantless data collection. If you were subjected to this under a similar law, you may have grounds to fight back. We often think of the Supreme Court as distant, dealing with abstractions, but what happened this week proves that the Constitution is a living shield. It only works, however, if there are people like Jennifer Martinez willing to stand in the gap. Jennifer could have let it go. She wasn't facing charges. The investigation cleared her. It would have been easier to move on. But she chose the hard path because she understood that a right you don't assert is a right you don't have. This 9-0 victory is a reminder that in America, the government is the servant and the citizen is the master. It's a reminder that even in our most divided times, we can still agree on the bedrock principles of liberty. Here's what I need you to do. First, if you haven't subscribed, do it now. Hit that subscribe button because we're covering the Supreme Court decisions that mainstream media buries on page 17. Second, share this video. Send it to your family, your friends, your colleagues. Every American should know about this decision. Third, drop a comment below. Have you ever had a run-in with government officials who felt above the law? Are there similar laws in your state? The Supreme Court has spoken. The hidden law is dead, but the price of liberty is eternal vigilance. Constitutional rights require citizens who know them, assert them, and hold government accountable. Jennifer Martinez is a hero, not because she did something extraordinary, but because she did something necessary. She stood up when it would have been easier to back down. What happened this week is a victory worth celebrating, but it's also a reminder that freedom requires constant, vigilant defense. The question is, will you be ready when that defense is needed? Thanks for watching. I'll see you in the next one.